Welcome to the Moss Adams webinar, After Stark Law and the Affordable Care Act, Scrubbing in on Physician Payments. And thank you for joining us. Our panel today will help you take a closer look at the legal ramifications and some recent litigation around physician payments and provide you with information and insights for you to have confidence around your physician payment process. But first, we'd like to address just a few administrative items.
Welcome, and thanks for joining us. Moss Adams is pleased to present another in our ongoing series of continuing professional education webcasts. Our presentation will start in a few moments. Before we begin, here are a few things to keep in mind. You can customize how you both view our presentation and interact with the presenter. For better viewing, close all other applications and turn up your speaker volume. You can also adjust window size and placement. At the bottom of your screen, you'll see a series of icons, each relating to a different aspect of our session. For example, you can click the File Folder icon to download the group attendance sheet and a PDF copy of today's slides. You can ask our presenter questions during the webcast by clicking Q&A in the bottom left-hand portion of the icon bar and typing in your question. We'll do our best to answer all questions during the presentation or follow up via email. We'll ask polling questions throughout today's presentation. Per the National Association of State Boards of Accountancy Webcast CPE standards, CPE credit will be awarded based on your participation in these polls. To respond to a poll, click the button next to your answer. If you're attending this webcast in a group, you must complete our attendance sheet to receive CPE credit. Please have all group members sign the sheet, and please remit only one sheet per group. Also note, today's session will offer you one CPE credit. To receive credit, you must meet the requirements as specified by the National Association of State Boards of Accountancy. You must attend at least 50 minutes of the session and respond to at least 75% of the polling questions. CPE credit can be awarded only to participants registered as themselves and is not available to participants who view the on-demand version. We'll track your progress and alert you when you've earned CPE credit. You can then click the certificate icon to open a PDF file you can save to your computer. As a reminder, the presentation you're about to see is not legal, investment, or accounting advice. We encourage you to seek the counsel of a professional service provider to apply this content to your specific circumstances. We're now ready to begin.
Good morning, everybody. Welcome to our presentation. My name is Laubach, and I'd like to introduce our two panelists. First off, we have Dennis, who is a healthcare lawyer with Davis, Wright, Tremaine. He provides advice to providers on a wide array of regulatory and transactional matters, and some of these areas include internal compliance investigations, voluntary disclosures, and defend healthcare regulatory enforcement actions. As well on the panel is Shirley. She's a director at Moss Adams and is a leader of the Healthcare Internal Audit Services. She provides assistance to clients on regulatory compliance, internal audit, enterprise risk, and the design and operating effectiveness of internal controls in every segment of a healthcare entity. I will be your moderator today, and I am responsible for the regulatory compliance consulting services for Moss Adams. I assist clients with regulatory compliance programs, investigations, and auditing. So today we're going to be talking about some key objectives. Our objective today is to make sure that we provide information about the physician payment compliance, including the potential risks, financial penalties, and liabilities for non-compliance. We're hoping to provide to you some tips and tools on how to structure processes to achieve compliance and prevent non-compliance. We will discuss some brief background, give some examples, some case examples, and then some compliance tips. So we're going to start off with our first polling question. Remember that we need you to answer the 4 questions that we have for polling. And our first question today is, how confident do you feel that you have a strong process in place to be compliant with the physician payment requirements? Please check one of the three. One is not sure, still has some doubts about our process, somewhat confident, completely confident, just here for the CPE. Please mark your answer. So we're getting our responses from everybody, and then I'll provide kind of an overall result. Okay, let's see what everybody has to say. Well, it looks like we have about 61% that are somewhat confident, and we got a split about 20% for not sure and completely confident. So hopefully some of the things that we talked about today will help guide you with your physician payment process. So first off, I'm going to have Dennis provide a little bit of brief background, and he can maybe tell us really what is causing the concern. Dennis, what can you help us out with that?
Sure, thanks, Lori, and good morning, everybody. What's causing increased concern now is the specter of the False Claims Act and its application to Stark. And just as brief background on Stark, Stark, as most of you know, prohibits physicians from referring patients to entities like hospitals and medical groups with whom they have a financial interest for Medicare services unless the Stark exception applies. And there are a slew of exceptions, as most of you know. If the entity or hospital then bills for patients that are referred improperly by the physician and receives payment, those payments are overpayments and need to be refunded to the Medicare program. What's happened more recently is that if the hospital or other entity has identified an overpayment in this way and does not return the overpayment within 60 days, then that overpayment becomes a false claim. And what's scary about false claims is that it's triple damages and up to 10 times the amount of the claim in terms of the amount that can be awarded to the whistleblower or the government. And that's troublesome because we'll get to later, it's easy to trip over Stark and commit a technical violation unwittingly, and it's easy or easier to start the 60-day clock running. So let me give just a brief background here on what's happened out there in terms of this increased concern. You can see that whistleblower complaints under the False Claims Act have increased substantially, more than 700 last year, recoveries in excess of $2 billion. And what we're seeing, again, is, you have the plaintiffs and the relators and the whistleblowers smelling the money. They've got 3 times the amount owed as damages plus the $10,000 for each claim. So they're seeing hospitals and entities tripping up over Stark, not returning the overpayments in time, and launching the whistleblower's lawsuit. What's interesting about the False Claims Act and the surge in the awards here is that healthcare is the epicenter. Most of the awards here in false claims, which could relate to any industry besides healthcare, are in healthcare. Okay, so how does Stark noncompliance get to the point of being a false claims violation? You can see here on this slide that what we call technical noncompliance with Stark. You fail to get a written agreement in place until later in the game. Your contract lapses. You don't re-up the contract. You have signatures by, say, the hospital physician that's late. There is a grace period under Stark, but let's say it's beyond the grace period. Those are easy ways to trip up over and violate Stark. There's no fraud involved. There's no intent involved. Remember, Stark is what we call a strict liability statute, so you don't have to show any intent that there was intent to overpay physicians, to induce their referrals. You just have to not meet these technical obligations under the Stark law. Stark also requires that the arrangement be at fair market value and commercially reasonable. Those are not what we call technical noncompliance. Those can become more serious. They can give rise to the kickback violations as well, and we'll touch on that in a minute.
So, Dennis, what are some of the other concerns to be considered in addition to the Stark Law related to physician payments?
Well, what's happened, Lori, under the Affordable Care Act recently is the imposition of the 60-day rule. So you can see from the slide here again, what is a false claim? False claim is basically presenting a claim, billing, or receiving a claim that's done knowingly. The falsity or truth is done knowingly. It's done in reckless disregard or with deliberate ignorance. So in the old days, it used to be that a false claim could only arise if you actually submitted a claim to the government or made a false statement of fact. Now, if you even properly submitted a claim, but you found out that the government erroneously paid you or you committed a Stark violation and you received that money, that you may have a false claims violation on your hands. Now, again, going back to the 60-day rule, the 60 days starts to run after you, quote, identify, unquote, the overpayment. And again, given the fact that it's easy to trip over Stark, that 60-day clock may start running, and again, automatically after the expiration of the 60 days, you've got a false claim. So the 60-day rule has really gotten some play recently, and we'll get to a recent case in that respect. CMS, because of the confusion and controversy surrounding the 60-day rule, proposed some regulations in February 2012 that attempted to clarify what the 60-day rule meant when the clock started to run. You can see in this slide some of the elements of that proposed regulation. The second bullet here is, I think, significant in that CMS said if the provider's actual knowledge of an overpayment is unclear, the provider must investigate with all deliberate speed to determine whether the provider actually sent a mistaken claim to Medicare and whether Medicare paid that claim. Now, CMS has put these regulations on hold, so they're not final, they're not the law, and one of the reasons why they put those proposed regs on hold was the Kane case, which you have here in this slide. The Kane case was a case that was filed in New York Federal District Court in June of last year. And if you read through these bullets here, you can see that essentially what happened is you had a hospital system that erroneously, inadvertently billed the New York Medicaid program when it had already been paid by another insurer, discovered that it may have a problem, and decided to look into it. So if you look at the third bullet, again, this was an inadvertent, it was basically a computer glitch that caused the erroneous billing. If you look at the third bullet, an employee there, Robert Kane, found out that there was an issue. He sent an email to hospital administration in April 2011 saying, look, we think we have a problem here. I'm not sure of the scope of the problem. I'm not sure the amounts of any overpayments, if any, but we ought to look into it. So Continuum, which was the hospital system, started to investigate. They began making refunds, and it ended up making refunds of over $1 million over a period of about 2 years. What's important here, if you look at the gap in the dates, the email first occurred April 5th, 2011. The last refund was done almost 2 years later, 2013. The government came in after Kane, the employee, became the whistleblower, and basically said that Continuum failed to take steps to repay all of those claims within 60 days after the claims had been identified. So they're saying as soon as Kane thought there might be a problem, the 60-day clock started to run. Now, if you focus on that for a second, you think about your own facility, your own institution, it's not uncommon you're going to stumble across what could be a problem, could be an overpayment. The government here, the Department of Justice, is taking a very aggressive tack in saying that we think that 60-day clock starts to run very early in the process. Laura, I see a polling question here.
Yes, sorry about that, Dennis. I was on mute, but I wanted to also comment on the prior slide. it really demonstrates some challenges in our organizations when it comes to overpayments and managing that, even if it is a physician contract, making sure that any overpayments that have been made related to that issue are actually paid back promptly, as well as tracking to make sure that those have been paid back promptly. I think sometimes we rely heavily on our teams to make sure that happens. So one quick question.
One of the issues there, Laura, if I can just interject something, is that, you know, a lot of times you'll discover that there could be a problem, and, you know, you haven't really determined that there actually is a Stark violation. You gather facts. Your outside lawyers will say, well, we need to see if we can develop a creative argument that Stark is not violated, and that may take some time. You know, it's in some cases longer than 60 days. So the Kane case, and again, it hasn't been decided yet. This is just a brief that's been filed, and everybody's looking at this, including CMS, in terms of whether they're going to issue any final regulations. The Kane case basically prompts us to become more aware of the fact you need to proceed in a reasonably expeditious manner, or as CMS would say, with all deliberate speed, to determine ultimately whether you've got an overpayment.
Got it. Great. Thank you. Let's talk about our first polling question. So if you, does your organization routinely sample and test physician payments for compliance? Easily a yes or a no. If you can please respond. While we're waiting, Dennis, could you, there was a question from the audience. Is Medicare Advantage plans considered Medicare as well in the guidance that you just discussed?
Medicare Advantage is not subject to Stark.
Okay, great. Thank you. So the answers that we received that
Laura, I'm sorry. Let me just follow up on that. I'm sorry. It's not subject to Stark, but if you have an overpayment under Medicare Advantage, the False Claims Act could still apply. So the 60-day rule applies not only to Stark and Medicare, but any overpayment. And if you look at the Kane case, it was a Medicaid case, not a Medicare case. Again, Stark is only Medicare fee-for-service. So, you know, you need to refund promptly.
Great, thank you. So looks like we have a large percentage of our audience that are actually routinely sampling and testing the physician payments for compliance. So Shirley and Dennis, Shirley, what should organizations do to manage the 60-day clock? What's some ideas on that?
Well, so here's an example, and this is one that we've seen in a number of hospitals. The hospitals implemented a back-end control, a detective control, for AP to review payments to physicians. And in this case, AP stops processing a payment to a physician because they couldn't confirm that there was a current and fully executed contract. Now, Dennis, in this case, AP stops the payment. So when does the 60-day clock start? Does it start when AP identifies this question, or when they turn it over to the compliance office for investigation, or when the investigation is completed, or what?
Man, good question, and it's really going to depend on the facts in the particular situation. I mean, in most cases, if you stop payment, you know, AP stops payment because they see there's a problem. Say they have a lapsed contract, or they're lacking a signature. I mean, it still may be the case that you don't have a Stark violation because one of the grace periods would apply, or maybe you find some other documents that may support what would otherwise be considered as, or concluded to be a Stark violation. So it doesn't necessarily start at that point. It would start at that point, however, if AP and everybody else knew that there's no way out of this. I mean, it is clearly a Stark violation, and that you've received money. You know, one argument that's made in such segments of the legal community is that until you've actually calculated the dollar amount of an overpayment, you cannot be said to have, quote, identified, unquote, an overpayment, because how can you identify unless you know what the amount is? And that obviously doesn't occur until you calculate the amount that you need to refund. So that could be further down the road. And this sort of highlights, Shirley, the uncertainty around this whole issue of when the 60-day clock starts running. You know, the best advice we could give is, if you think there's a problem, you really need to promptly start your investigation and complete it as quickly as possible.
Thanks. So looking at this managing our risks around that 60-day limit. I guess from our experience, I would say, number one, don't jump to conclusions. Don't think the sky is falling. Don't overreact. Don't send a whole bunch of emails out that say, we have a Stark problem, especially before you've even started your investigation. However, as Dennis has said, begin with all due speed to inform and include the appropriate people in your investigation. Start the investigation and carefully document your process and your thought process, your investigative process as you go along. Dennis, you want to add anything?
Yeah, one of the things we see fairly commonly is that, you know, most folks are going to commence the investigation. I mean, they'll conduct an investigation, they'll commence it, and they'll want to get it done as quickly as they can, but of course we all have other things in our lives to do, and sometimes the investigation bogs down. Sometimes the lawyer doesn't get back to his or her client, you know, within a quick time frame. So I think it's really, you know, up to the compliance officer to continue to push on this. If you look back to the Kane case, if the Kane case, for example, is upheld in favor of the government, then, you know, they're going to say if you basically went a week or two without continuing the investigation and let it bog down, you know, that's when the 60-day clock started to run. Certainly, if you decide either formally or informally to terminate the investigation or put it on hold, they're going to say the clock starts to run there. So what I usually say is you really need to make sure you keep the ball rolling almost on a daily basis. You want to be able to show if somebody comes back in, a whistleblower of the government, that, no, you didn't let it bog down. Look what I did. I sent some emails out. I talked to so-and-so. I collected documents, just to keep that process going.
So one of the big areas around is managing the 60-day clock is around that credibility of the reviewers and the final investigation report. Do you have any comments on that in particular, Dennis? Just
to say that, and we'll actually get to this in a different context under the couple of other cases we'll touch on, but as in any investigation by the government or any dispute with the government, your outside reviewers, your consultants, and the quality report is going to be important in terms of, you know, your credibility in the eyes of the government. If you have reviewers that are sub-quality, you know, reputation, we'll say, the report is shoddy. Even though you may be on the right side, it's going to undermine your credibility with the government. So that's important from a practical standpoint. One thing, Lori, on this slide I want to touch on for a second is the last bullet, which is the Stark Self-Referral Disclosure Protocol. There is, as most of you know, a voluntary disclosure protocol that's been set up by CMS to self-report Stark violations. And, you know, what's behind this is CMS said, look, we want to know what these violations are. If you follow our protocol and you're good citizens, we'll go light on you in terms of the amount of the actual penalty we're going to impose on you. And unlike many other disclosure protocols and voluntary process set up by the government, this one actually has been pretty beneficial to a number of providers. You know, our experience in terms of, well, actually our knowledge of what's been decided out there and the penalties meted out under CMS, under the SRDP, is that we're talking in many cases cents on the dollar. So the self-referral disclosure protocol is a way to tell your story to CMS. Look, these were technical violations. We're good guys. We had a good process in place, and these just fell between the cracks. Go light on us. And they have in many cases. There have been self-reported overpayments in the triple digits, millions of dollars. The highest amount of any settlement, and these are settlements now CMS will enter into with the provider that's done this, is $537,000. And that was on a multi-million-dollar disclosure. So this is definitely an avenue that you want to consider using if you do, at the end of the day, conclude that you've got stark violations can require some repayments.
And I think it's also a good document to pull up and look at how you're doing your investigation, because it has some really good protocols in there as well for that. So one of the big things that comes in play with Stark is fair market value. So maybe you can tell us a little bit about why fair market value is important, and then we can go from there.
Sure. All of the Stark exceptions require that the arrangement with the physician be at fair market value and be commercially reasonable. And as I mentioned, the technical Stark violations, late signatures, lapse contracts, they're more apt to receive favorable treatment from the regulators as opposed to fair market value violations. And they're easier to fix. I mean, you can get a physician to sign a contract to stop the bleeding on a Stark continuing period of disallowance. If you have a fair market value violation, however, the government may tend to think that you're overpaying physicians to get their referrals, or you're undercharging them on a lease to gain favor with them, which raises the specter of the anti-kickback statute, which is criminal in nature. It's a felony. So the other aspect of fair market value is that if you need to fix a fair market value problem, you're going to need to go to the physicians or the medical group and ask them to either lower their compensation to get it to fair market value going forward, and or return monies they previously received, and neither of which, as we can all attest to, is something the physicians like to do. So fair market value is important under Stark.
I think you're on mute, Laurie.
Sorry. How often does your organization review fair market value and complete and or update evaluations for applicable contracts? So what's a fair market valuation, ? Annually, biannually, at contract execution and renewal, and never. We do not have a process in place. You go ahead and mark it and hit submit. Remember, as we go through the presentation, if you have any questions, feel free to open up the question box and submit it to us, and we will try to answer it as we go along. So we have a resounding at contract execution and renewal of 61%. Looks like we have annually and biannually in there as well. So we have a couple cases that Dennis has provided to us that might be good discussion related to fair market value. Do you want to talk about the Toomey and fair market value case, Dennis?
Sure. And these are the two cases that I'm going to discuss briefly are both fairly recent. Here's Twomey Health System. It's 2012. Fourth Circuit is on the East Coast, so it doesn't have any technically binding effect in California, but it's certainly going to be instructive and has been instructive for other court decisions and cases coming down out here. And if you look at the dollar amount here, $237 million stemming from Stark and kickback. This was not pursuant to a voluntary disclosure, obviously. This is a whistleblower that came in. You take a look at very quickly the elements of the arrangements here. Part-time employment agreements with 19 specialists. It was outpatient only. It was a 10-year term with a 3-year non-compete. You had base salary based on collections, productivity bonus based on collections, and incentive bonus. Physicians were provided other perks, insurance, CME, cell phone, other support. And even though they were part-time, they received full-time benefit levels. These are employees now, not independent contractors. So the government came in. They did intervene with the relator. And you can see here, if you go down the bullets, the case did not unfold in a way that was good for the provider. The government basically said that the arrangement was not at fair market value, that it took into account the volume of value referrals. again, fair market value needs to be something that's based on something other than referrals, other than referral value. What's the legitimate business underpinning of the deal? What are you paying for that's fair market as a legitimate business interest as opposed to referrals? The other thing Twomey did here is they opinion shopped. They basically went to one valuation company, did not like the number they got here, or maybe more accurately, the physicians didn't like it, and they went to another one and got a better report that is more favorable to physicians. And if you look at the second bullet here on the opinion shopping bullet, they went to 4 law firms. I mean, the first 2 questioned the validity of fair market value. They finally found a firm that was willing to opine that this was okay. So the court held, again, no fair market value. And let me go to the takeaway slide here.
Yeah, and I think the ways that I got from this is that you really need to avoid those attorney and valuation expert shopping. There's a perception, too. I mean, you may have an issue with your valuation expert, but you need to make sure that it doesn't also have a perception that you're shopping for a valuation expert as well. But you need to make sure before you hire somebody that they have the attorney and valuation expert have the right skills to do the work for you. And you need to make go ahead. You also want to make sure your reports and opinions, one of the things that, people feel that they get a valuation done and that covers them, but that's not really necessarily the case. Some organizations think that a piece of paper will suffice, but if it's not done properly and doesn't have the right information in it or the supporting information that needs to be in there, it could be faulty information that you're relying on. So read your evaluation reports very carefully, confirm what data they use. Is it actually data that's independent, or is it a perception or an assumption, and support for fair market value conclusions. You want to also make sure it has depth and support. Some of the reports that they received were very slim. They were not, they didn't have any real reasonable support behind them from an independence perspective.
The scope wasn't well defined.
Yeah. Anything else?
Yeah, those are good points. And in fact, the valuation report, the first one that was issued here was 3.5 or 3 pages long. It was really quickly put together. And again, that wasn't disclosed as part of the process here by the provider. The other thing, to Lori's point about making sure that the reports and opinions stand on their own, is that when the investigation occurred here by the government, they found out that the physicians were getting full-time pay for part-time work. And they were getting paid at a 90% compensation level, even though their production was at 50 to 75%. Neither of those facts were included in the valuation report. So, again, as Lori said, you really need to make sure that the report stands on its own, it's thorough, because when the investigation occurs, if it's thorough, they're going to find stuff out that may not have been included in the report. One other interesting note on the attorney law firm shopping here is that in most states there's a rely on counsel defense. In other words, you get an opinion from the law firm and you can, basically it's your insurance card to get you off the hook in the event of a violation. Here, because and that was asserted here by the providers, here because they did forum shop or did attorney shop, and the court concluded that they did that because they're really acting in bad faith to try to find a right number to fit what they want to do as opposed to what the true evaluation should be. They rejected the reliance on counsel defense. So the attorney letter did not help them here.
And in a more recent case is the Halifax case. Do you want to maybe kind of go over some of the observations from that?
Sure. Halifax is a Florida case. It's March of last year. It's settled for $85 million. This has an interesting twist to it. And there were employment agreements, hospital into employment agreements with oncologists. There were 6 of them. Physicians received a salary and bonus. And if you look at this last full bullet here on this page, the bonus was equal to 15% of the operating margin for the medical oncology program. And then the bonus pool was divided similarly. So you basically had a situation where the hospital was looking to performance with respect to a certain service line overall, and using that as a way to determine how much and whether the physicians got paid. Again, similar analysis here by the Halifax court. They rejected the provider's argument here. The employment exception under Stark did not apply because it was not fair market value. The compensation did vary with volume of value referrals, which you can't do under Stark if you want to be able to say you're at fair market. And if you look at the last two bullets, or the second and third bullets, I think these are instructive here. You can pay for productivity bonuses based on services personally performed, but the incentive bonuses here were not based on personally performed services. Again, they were based on performance and outcomes in the service line as a whole. And the next bullet, the incentive pool was divided up based on personally performed services, again, but included total operating revenues of the oncology clinic, which included referrals from the oncologist defense. And again, the last bullet, because the court concluded that the provider here did some attorney shopping, was just looking for the right opinion as opposed to the opinion supported their position as opposed to the right opinion, they rejected the advice of counsel defense.
And I think some of the lingering questions that are still out there is about whether or not a hospital can set that physician compensation at a level that exceeds collections for physician services. And I think one of the big two things that need to be thought about as you look at Halifax and what has happened with their bonuses is some things that we typically talk about with our clients is there a financial relationship rationally designed to achieve a legitimate purpose or purposes of the hospital? Is it a rational designed to be able to support the services and purposes of the hospital? And also, is that fair market value? So when you get into collection for physician services, both cases had concerns about the fact that there was payment for the physician services that was in excess of the collections. But that's not what Stark in particular has elements about, right, Dennis?
Right. I think what's concerning here is the last bullet, and that's, again, you can pay bonuses, you can pay based on performance, but it's from Halifax, they're almost saying that, look, you're not going to be able to pay based on service line performance or performance in a certain outpatient or clinic service if any of those revenues are in any way associated with referrals that were made by these doctors. And that includes facility revenues, right? I mean, the doctor treats the patient, the facility receives a reimbursement, and that's troubling because, there are arrangements all over the place where hospitals pay bonuses based on performance that they believe aren't related directly to the referrals made by the physician. You think of, co-management deals out there. They're based in significant part on overall performance of the service line that's being managed by the physicians that the hospital has a contract with that do refer to that service. So it'll be interesting to see how this Halifax case unfolds.
Yeah, definitely. So I think, Shirley, you want to maybe talk a little bit about the establishing the fair market value of Stark and kickbacks?
Yeah, I think that based on everything that we've heard this morning, what are those overall lessons learned? And I guess bottom line, make sure your fair market value process is sound, that it involves independent and objective documentation and support. That includes the documentation of your rationale for developing the fair market value, including the actual scope, a very clear and accurate scope of what the physician is going to be done because is going to be performing, because that really forms the foundation of the fair market valuation itself. So if you start with an erroneous scope, you come to an erroneous conclusion. So again, make sure your assumptions are documented, your process is sound. Make sure that you have an appropriate and a credible source for that valuation.
You know, one thing just to add there, Shirley, is that we often get questions as to, well, what does the government require in terms of establishing fair market? What criteria do they require that we use to determine that? And they don't. I mean, there's no formula. There's certainly no rigid formula. It's basically an economic analysis. So, you know, you use the typical economic analysis to establish fair market value. That should be sufficient.
Great. So Shirley, do you want to talk about maybe some preventions to be proactive?
So as you can see on this slide, there are a number of points, and I think all of them are important. But bottom line, follow the basic tenets of an effective corporate compliance program, and I think we all know what those are. Prevent, detect, educate, correct, monitor the violations or the potential violations. Laxity and delay in oversight and inadequate follow-through can help feed your compliance problem rather than help to create solutions. And they can also turn good employees into disgruntled employees, which is absolutely what we want to prevent. That third bullet is really key. Never, ever ignore your complaints. And I know we've got legitimate complaints, but I think that in order to determine if they're legitimate, we're first going to have to investigate. So I would say never ignore your complaints. And those complaints can come from anywhere. It's not just your hotline. They can come from people standing in the hallway and talking to you, people in the parking lots bringing up problems, your emails, your phone messages. So it comes from everywhere, and including government probes or initial questions. So I think all of that needs to be consolidated in one place so that you can actually look at them. So preventing whistleblower lawsuits.
Shirley, let me if I can just interject a couple quick points on the prior slide just to add to what you said. The second to last bullet, regulatory monitoring of contracts. I mean, we get questions, you know, how should we do that? I mean, there are different ways to do it, but I'm a strong proponent of you need to have this hardwired. You need to have some sort of electronic system in place that will automatically do this. If you defer to the human element, I mean, there's going to be error. So most hospitals now have some sort of hardwiring process to monitor contracts. The severance release agreements refers to, you know, if you've terminated an employee or there's separation with an employee, what we're seeing more now of is basically releases in the severance deals where, although there's a question whether or not this would be legally enforceable, you have the terminated employee basically agree that this is the full amount of the separation dollar amount. In other words, they're not going to become a whistleblower. If nothing else, that can become a deterrent to somebody becoming a whistleblower. They've already agreed to it.
Those are great points. Thanks, Dennis. So, Shirley, you want to?
So, yeah, just to continue what you were saying, Dennis, to prevent whistleblower lawsuits, what are some of your thoughts in this area?
They're tried and true points here. You know, investigations ought to be done under attorney-client privilege, and the attorney-client privilege ought to be impressed immediately. One interesting side note here is that audits occur all the time without attorney-client privilege. And I think compliance officers need to make judgment calls in terms of when a particular kind of audit in a certain context, you know, might turn something up that you may want to protect. Those sort of audits ought to be protected by attorney-client privilege. Again, circle the wagons, the second bullet point here. You ought to have as small a group as possible that is aware of the problem. Emails are killers. It's, you know, that's self-evident, I know, but we still see emails where employee X has sent an email to employee Y saying, our attorney just went home and we're screwed. We've got a Stark violation, and that's not a good paper trail. Bullet point 3 encompasses different issues here in terms of how far up the chain of command should you go when you know you've got a real problem here. I mean, my view is it should go all the way up. It needs to be managed, obviously, in how you do that, but certainly senior management, and there ought to be a mechanism anyway for the board, either through direct report to the board or the audit and compliance committee of the board, to be aware of what the issues are. If for no other reason, employment survival tactic for the compliance officer. Again, we've talked about in detail proceeding with all deliberate speed to completion of the investigation. Follow up on corrective action. So you need to implement corrective action. You need to follow up. We had a client not too long ago that basically committed the same violation twice, did a good job getting things together on the first violation, but basically just let things go. They didn't follow up on the corrective action. They probably would have prevented the second event from happening. So they've already got one strike against them with the government coming on this. And then the last bullet point we talked about before, really consider the use of the SRDP, the Voluntary Disclosure Protocol imposed by Stark, if you have any sort of significant number here. If you've got a very small number, and we get questions on this, let's say, for example, you've got an $8,000 overpayment that you calculated because of a Stark violation. You may not want to use the SRDP for that, and you may be best off just dealing with your Medicare fiscal intermediary and just refunding that amount without going through the whole process, because again, unless it's a false claim, the most they can tag you for is the $8,000. One thing that the SRDP does, by the way, is once you've submitted the disclosure, it will cut off false claims liability going forward. That's one of the carrots that CMS has used to get people to use that.
Great, thank you for that. That's good information for our clients. So Shirley, now what should compliance and the organization do? What are some questions?
So let's start with those questions. And I'm sure a lot of you are asking these kinds of questions and following up already. I would say, has a contract been signed and dated by all parties, and was it executed prior to services being performed? And in your auditing and monitoring program, are you checking to make sure that that's occurring? Second question, maybe, are invoices for payment in line with the contract terms? That is, are they accurate per the contract detail, and do they contain the required and adequate support, such as timesheets or call schedules, whatever those are? If a support for an invoice included a time card or a time report requirement, was the time actually spent in accordance with the contract? And did the time record tie mathematically? Was it correct? And was the invoice, time record, etc., submitted timely? And do you have a clause in your contract that defines what timely is? Is it 30 days, 60 days, whatever it is? Was the invoice properly approved per the organization's signature authority? And was that physician invoice approved by someone who was in a position to know the physician's work, responsibilities, and performance? Here's another question. Has there been an independent fair market value analysis evaluation performed for the contract? And this applies to a physician or to lease arrangements or any other kind. Were the payments at or below fair market value? A lot of times the fair market valuation reports that come from outsiders have a term, an effective term. So is the valuation still effective? If the payment is actually above the 75th percentile of the valuation, is there appropriate justification in that accompanies the contract file to document why the organization chose to go above. For physicians with an income guarantee or a draw, are you reconciling, and are those reconciliations completed, and are IRS Form 1099s issued? And how do you ensure that that's occurring? Is there a process in place to reconcile and true up the accounting for physicians with an income guarantee or a draw if they leave during the contract term? And if a balance is due, is there a process to obtain reimbursement from the physician and or evidence of collection activity? We often see that there's a calculation that occurs in a reconciliation, but we often also see that when there is a balance due, there's a hesitancy on the part of the organization to go back and ask for payment. So what is your process? How are you confirming that that process is working? For physician arrangements with a loan component and forgiveness clauses, are these reconciliations completed, and are IRS Form 1099s issued in these cases? So these are some of the questions. They're not all of the questions, and the questions really come by starting by understanding Stark and then reviewing the contract itself and making sure that the payment is consistent with the contract. And when you look at the contract and you look at the payment, all these questions kind of fall out as a natural process of your monitoring. So think about the controls and processes that you'd like to have in place. Best practices that we've seen are a checklist to make sure that the payment process is stepped through appropriately, that all steps are followed to initiate the contract, that there's legal and compliance sign-off, that it's elevated to the board for review, that there is a centralized location for all contracts to reside, and that all parties along the initiation to payment path have access to at least view those contracts to confirm those contracts exist. You wouldn't want AP to be making payments without having visibility on the fact that the contract is there, that it's current, and it's been properly executed. You also wouldn't want to have AP making payments if they had no comfort that the payments were aligned with the terms and conditions of the contract itself. So they do need to have visibility.
Shirley, just like something there, I think that's a really important point. And when you really get down to the nitty-gritty on that, you know, does AP make the call on that, or does compliance make the call? Sometimes in finance, the finance department, they may get pressure from the physicians or their colleagues. Look, just get the payment out. The doctor's going to get around to signing this within the next few days. You know, there's no problem, et cetera, et cetera. There may be pressure to do that. It's all the more reason to have a hardwired process in place. Or some of my clients now have the compliance officer really, or someone from compliance making the final call on whether or not the payment's going to go out. And, you know, with the expectation they're going to kick the tires a little more than maybe somebody in AP might.
We've seen that as well. There are a number of clients that we have that have their compliance officer review to confirm that the payment is in line with the contract terms and conditions, and to confirm that a contract is current and in place. However, compliance officers cannot and should not, from our opinion anyway, be the ones that are approving the time that the physician has entered on their timesheet. That is something that should be done by someone who is in a position to understand what the physician is doing and has some oversight role over that physician's work. So going back to the controls, just a few more, and I know we're running out of time, so I'm going to rush through these. Do you have a routine that monitors physician payments? And Dennis brought this up earlier. It needs to be institutionalized in your organization, and it needs to be in a fashion that allows all contracts and all payments to have an equal opportunity of getting selected. You need to have a process in place that flags the vendors in your system who are physicians, whether they're medical groups or individuals, because otherwise you'll never know whether you have completeness. That is, every payment made to every vendor that is a physician has to be attached to a contract. You won't have completeness if you start by looking only at contracts. Monthly, quarterly, and annual reconciliations for applicable physician arrangements. We kind of talked about some of the questions you'd want to ask. You need to have a process in place to audit and reconcile these to make sure that you're functioning appropriately. There needs to be a year-end physician contract review process for 1099s. Lease walkthroughs is something that should be occurring by your organization to ensure that the actual lease ties to the contract and to rule out any encroachment or inappropriate use, such as the use of a waiting area that isn't in the agreement, square footage, or the use of copy machines or scheduling staff that is, again, not in the agreement. And finally, as Dennis pointed out earlier, your corrective action process. It's not enough to have a finding and to have a corrective action, but the combination of compliance and internal audit need to be involved to ensure that corrective actions are implemented promptly and that they are audited to be sure that the implementation stuck.
Thank you, Shirley. I think we have another polling question at this point. Does your organization verify that a current executed contract exists before a payment to a physician is disbursed? Is it each payment, as needed, never, not sure? And remember, you have the opportunity to ask our experts on the panel questions, and if you have a question, feel free to put it onto the question Q&A section or button of your screen. Let's see what everybody has said about this. Looks like we have a majority of the responses say as needed, with some folks saying that it's each payment. And then there's 22% that says they're not sure, so it's time to go in and look and ask those questions that Shirley was actually asking. So Shirley, maybe you could actually talk a little bit about, how to identify an issue.
So on the as-needed answers, I would go back in and see if you don't have an issue, because I'd want to know, well, how did you define as needed? But anyway, identifying an issue. What do you do when you find a problem? If you audit and you find a problem, you have to address it. You can't ignore it. You can't cover your eyes and say it doesn't exist. It's not this don't ask, don't tell. Once you have identified it, there is no going back. You have to conduct the investigation, identify the facts and history, and figure out whether you have a problem or not. And based on that, you can determine whether there's a dollar impact. You can determine whether there needs to be a repayment. You can determine any of those other things. But you've got to start by defining what your problem is, or your potential risk area is, and then auditing to figure out, investigating to figure out what you really have, what in order to confirm what problem actually exists.
Great. Well, thank you. You also want to make sure throughout this that legal counsel is involved, because it's important to keep them up to date with what's going on with the issue. Well, we're at the last 2 minutes of our presentation, and if you have a question today, but you find that, but later on, you don't have a question right now, but you'd like to ask a question later on, our contact information is on this slide, and it's available through the link that you received. You could send it to our moderator as well, and we can respond to you and give you back some information. We appreciate the time that everybody's taken to listen to this valuable topic, and if you have some additional items that you would like to have us seek out an expert or have us present on, please make sure that you email one of us to let us know what those topics are, and have a great day. Thank you very much, everybody.
Thank you.
Thank you, Pamela.